Hi, I'm Ed Bacon, the Rector of All Saints Church, Pasadena. Whoever you are and wherever you find yourself on the journey of faith, I hope that you'll find something here that speaks to you. Welcome.
I'm trying to be all literalist about the time here. It doesn't say 10:15 yet. I have 10:14, but what the heck. This is also the Rector's Forum, and I am not the Rector. I am Susan Russell, one of the senior associates here, and I'm delighted to welcome you to this forum, Rector's Forum on Easter 2. We're glad you're here. I'm going to spend as little time as possible introducing these fabulous people so you have time to hear from them. But I could not be more thrilled to have them here today to help us unpack. The title of today's forum is Prop 8, DOMA, and the Arc of Justice. And we're going to look at the marriage equality cases through the lens of progressive Christianity. And so I got to tell you, Holy Week is not the week I had planned to spend, be obsessed with a bunch of Supreme Court arguments. But it is how it shaped out, and we're now on Supreme Court watch as we wait to see what they're going to do. So we have some eminently qualified folks who are going to help us understand how we got here, what happened, and what's at least likely or possible to happen next. So I do want to give you a little background on who we've got coming up. Linda Burrow is a longtime member of All Saints Church and a former vestry member. She, luckily for us, was serving on the vestry during the Prop 8 election time, and she authored our resolution on marriage equality, which states in part, our active participation in the discriminatory system of civil marriage is inconsistent with Jesus' call to strive for justice and peace among all people and respect the dignity of every human being. And I think that deserves an amen. Good job. Linda also authored a brief on behalf of Yale law professor William Estridge in support of same-sex couples seeking to overturn their exclusion from civil marriages, and brings a wealth of knowledge and experience on the marriage equality cases. We also have Albert Giang, another active parishioner and founding member of our 20s, 30s ministry. Albert worked on one of the early challenges to DOMA, which resulted in the first time someone was actually compensated by the federal government for benefits denied to a same-sex spouse. Recently, he co-authored all of the briefing on behalf of Equality California in the Prop 8 litigation, including their most recent amicus brief at the Supreme Court. We're deeply grateful to these two active parishioners and able attorneys for their willingness to lead us this morning through this conversation. And so please join me in welcoming them, and let's get started.
Good morning. So I'm going to be the first part of the arc, and then I'll hand it off to Albert for the events of last week, what we think will happen coming out here. So I'm the scene setter, and I'll try to do that as quickly as I can. But there's a lot of scene to set. And I'm going to start in 1971-ish. Quickly, I know. It's a long time ago. It was before Albert was born. It was a time before many of us even knew we knew gay people. And in 1971, the California marriage statutes were changed, and they were changed for reasons having nothing to do with anything we're talking about here. They were changed because there were distinctions in the marriage statutes that said that men could get married had to be older than women when they got married to each other in California. And the 18-year-olds got the vote, and a lot of things were changed, and in part marriage was changed. And when they changed the age distinctions, they took out the men and women part because you didn't need it anymore because the rule was the same. So for a few years in the 1970s, the law in marriage said that marriage was a personal relation arising out of a civil contract to which consent of the parties making that contract is necessary. And in the mid-1970s, a few same-sex couples picked up on this, showed up at county clerk's offices and asked to get married, and they were all turned away. And in 1977, the law was changed, not in the Constitution, but in the law, in the statute, and it was amended to define marriage as a civil contract between a man and a woman. they didn't change a different provision which said that a marriage contracted outside this state would be valid so long as it was valid in that state. And for 23 years, if there had been same-sex marriage anywhere else, it most likely would have been recognized here. That changed, we know, in 2000 with the Knight Initiative, Prop 22, which, just to show you how much times have changed in a very short period of history, passed with 61.4% of the popular vote in California, and carried all but 6 counties, all of which are right around San Francisco. And that provided that only a marriage between a man and a woman is valid or recognized in California. It was our own private little DOMA. And timelines become important here because that happened in 2000. In 1999, the first domestic partnership law was passed. And it was limited, the rights were limited, but it was a beginning. And as soon as the Knight Initiative passed, there was a whole bunch of litigation about how the domestic partnerships were inconsistent with the Knight Initiative. And the California Courts of Appeal said, no, domestic partnerships are different. And that turns out to be really, really important and a victory. And part of my scene setting here on the Ark is about the little victories that lead up to the big ones. And for that, I'm going to give a quick shout out to Thurgood Marshall. Because, I'm serious, because Brown versus the Board of Education didn't come out of nowhere. It came out of a long series of very small incremental victories in little courts and in big courts, including several Supreme Court cases about whites-only primaries and racially restrictive housing covenants and graduate school admissions and a lot of things that led up to Brown versus the Board of Education. And it's easy to get impatient and to want the big victory because the big victory is right. But it's the little victories that make that big victory happen, and it's the little victories that make that big victory sort of acceptable and stick. Exactly. The other thing that Thurgood Marshall set in motion and that has really been a hallmark of some of the brilliance of the cases beginning in 2000 with respect to the pro-marriage equality side and how they are litigated is strong leadership on who is speaking on your behalf. And it's not just selecting the plaintiffs. And Albert will talk a little bit about Edith, whose name flies out of my head every time, who is the plaintiff in DOMA, in the DOMA case, which if you haven't sort of focused on her, you can't have picked a better plaintiff. Because here is this beautiful, incredibly well-spoken, gorgeous woman who was with her wife for God knows how long. And what is her issue about? Inheritance taxes. So it's something that, like, the right can wrap their minds around. She's extremely palatable, but those things are important. And the other thing that's important is who are, not just choosing your plaintiffs, but who are your amici. And the amici are the friends of the court, are the people who file briefs and make arguments on either side, who aren't the parties themselves. And technically, they are independent voices. And anybody can at least ask for permission to file an amicus brief. What has been interesting about the marriage cases and other civil rights actions is how the people leading the charge toward the right, in this instance, now it's Ted Olson and David Boies, but it has been various people throughout, have really organized the people who are doing those speaking. Who is writing the brief? What is the point they're trying to make? Who is signing that brief? Are we getting leaders of conservative congregations signing the religious brief? Are all of these messages helpful and consistent with what we're trying to accomplish? Very unleft. If you think about, right? Whereas the folks opposing marriage equality, in particular, the folks, when we talk, we can talk about Lawrence v. Texas, which was the sodomy law case, they're a mess. They've got all these folks writing all this crazy stuff, and it just doesn't help. And if you think about in general, right, it's the right that has their talking points. We're all in message. We're all going to, we're all focused on the topic. And the left is all over the place. In impact litigation, it's the opposite. And it is what helps make things get done. And that's going to be, I think, especially important, if not dispositive, with respect to the Prop 8 decision in the Supreme Court. And Albert will talk more about that. But I'll come back to marriage now. As I'm sure you all know, we'll fast forward to 2004. Gavin Newsom said, denying marriage to same-sex couples is unconstitutional, and I'm just not going to do it anymore. Let's all get married. And a bunch of people did. Not surprisingly, he was enjoined, and those marriages were declared invalid, but the ball was rolling in a big way. And that led to the litigation that was known as in re marriage cases. And ultimately that led to the 2008 Supreme Court case. Now, in 2008, once again, the timing gets really important now. In 2008, the California Supreme Court declared that sexual orientation is a constitutionally suspect basis on which to impose differential treatment. Now, that made, under the California Constitution, sexual orientation equal to gender, race, and religion in terms of a characteristic on which we cannot discriminate. It's huge. And it goes well beyond marriage. And it means that if you're going to discriminate on the basis of sexual orientation, you have to show that the standard is called strict scrutiny. What it means is there has to be a compelling state interest, and the law has to be necessary to further that interest. There are almost no statutes or regulations that discriminate that can ever satisfy strict scrutiny. Compare that to the other end of the spectrum, rational basis, which can be just about anything. And really all you have to do, and often it makes a lot of sense. You have safety regulations where people can't be too tall or too short because it actually really matters if you can fit through the hole or carry the thing or whatever. But to raise sexual orientation in the California Constitution to that level is not just a legal thing. It is a stamp of value. And it means that not just for marriage, that the world has been recognized as now being different. Lots of legal wrangling, but ultimately the California Supreme Court agreed that same-sex marriages were going to start on June 17th, 2008. On June 2nd, 2008, Prop 8 qualified for the ballot. And in California, you can amend the Constitution with a bare majority of the vote of the electorate, so long as you collect not that many signatures. And they collected that many signatures, and so 2008, as I'm sure you all remember, was a really wild time because you couldn't get a florist. 18,000 marriages. But, and I think half of them were here. But at the same time, there was this looming Prop 8 thing. And of course it happened, and there were, of course, the inevitable lawsuits. And the inevitable lawsuits first were in the state system, which led to, in 2009, this California Supreme Court saying Prop 8 was constitutional. Interestingly, making very clear that this was a narrow exception to the Equal Protection Clause, meaning we're not changing this whole thing about sexual orientation having the same status as race, etc. But because we're looking at the California Constitution and not the federal Constitution at this point, the California Constitution has carved out this little thing, and the electorate can do that. Nonetheless, because the right existed, it wasn't like something got created by the California Supreme Court earlier in the year. It existed. All those marriages were valid. And the world did not stop turning. The day the Supreme Court declared Prop 8 constitutional, the Perry cases, the marriage cases that were heard in the Supreme Court were filed. And now we're talking heavy hitters. We had heavy hitters before, but these are big hitters. David Boies, major, giant, left-leaning litigator, commercial litigator, represented Al Gore in Bush versus Gore. Ted Olson, Bush Solicitor General, widower as of 9/11, represented Bush. And Olson had said and had done a fair amount of writing about the conservative case for gay marriage, about how the values, and this has always been one of those things that never made sense to me either. You know, what do you mean you don't want people to get married? And that was and that's been his point. There was a lot of uncertainty among marriage equality groups. Is this a good idea? Are we too early? Oh my God, look at who's on the Supreme Court. Do we really want them deciding this at this time? But these guys were going ahead. The state refused to defend the law, which is also going to be really important, and Albert will get there. And thus, the proponents of the statute were given standing to defend the law. There was a trial, and the reason there's a trial is that, you know, when I was talking about you had to show a compelling state interest, that's a fact. Is there a compelling state interest, and does this further the compelling state interest? That requires facts. Sort of like even on the rational basis, like, do you really care if the person can carry the stuff? If you know, and what is the interest we're trying to further? There were 50 pages of factual and credibility findings ultimately at the end of that trial. And at the end of that trial, Judge Vaughn Walker in the Northern District of California applied strict scrutiny, found that Prop 8 didn't meet it, and struck down the law, stayed the implementation of his order pending all of the appellate stuff. There was a lot of sort of interesting gossipy drama about that, starting with the alleged fear that the proponents had about testifying on TV. It was going to be streamed, and that was enjoined because the proponents of Prop 8 were allegedly fearful of their safety. After the trial, Judge Walker revealed what was, up until that point, one of the worst kept secrets among the judiciary, that he himself was gay and in a committed relationship, which led to a disqualification proceeding, which was denied. And the case went to the Ninth Circuit as we always knew it would. And in the Ninth Circuit did this very interesting thing. They said, they actually didn't focus on whether there's a right to marry in the federal Constitution. What they focused on was whether, if there was a right under a state constitution, somebody could then come and take it away. And they held, no, you can't. Now, Judge Reinhardt, who wrote that, is his wife heads the ACLU in Los Angeles. We know his politics, and he made it very clear in the opinion that if they had to go further, they would have, but they didn't have to, and this was a way to get people to sign on, which gets back to my incremental victories. That if you can get judges to agree that that you can't take away a right that existed, and that gets you where you want to be, that's a victory. It's a step in the right direction. And now we're at the Supremes. And a few little things. Judge Walker, when he wrote his opinion, it was in effect a very long, detailed letter to Justice Kennedy. Justice Kennedy had written Lawrence and had made it very clear what factors he was looking at in striking down those laws. And Judge Walker's opinion is very focused on providing him with what he needs, what we hope is what would be what he needs to strike down that law. The standing question, and Albert will talk more about this, is really interesting and complicated for legal wonks. In the middle of the Ninth Circuit proceeding, they stopped and asked the California Supreme Court, oh, wait, do these people have standing under state law? The California Supreme Court said, yeah, they do. That doesn't necessarily mean it has anything to do with under federal law, but it does under state, which has implications for other initiatives going forward. But the important thing is, when we start prognosticating, there are all kinds of really great scenarios that are short of a full-on win. And what is also really clear is that as we all know, the horse has left the barn here. Prop 8, Susan's saying we have to end by 11, so I'm going to stop. But I'm going to say one more thing, which was Prop 8 passed by 10 percentage points less than Prop 22 in 8 years. If you held if you held the election now, things might be very different. And that's not lost on those 9 folks in the black robes. So with that, I'll turn it over to Albert.
I'm guessing that many of the folks in this room have been following some of the Prop 8 and DOMA litigation. So I'm going to speak both quickly and I'm going to try to oversimplify at the same time, given our time constraints. But one quick thing. How many people are familiar with the legal doctrine of standing based on just hearing some of this? That's great. About heightened scrutiny? Okay, great, because this is going to go a little fast, so strap on your seatbelts. We're in the Supreme Court now, and as Linda pointed out, we've had the pleasure, actually, our firm has represented Equality California throughout the Prop 8 litigation in filing amicus briefs on various issues, but in particular the standing issue, which I think may be a way that you get 5 votes from the Supreme Court in the Prop 8 case. So we were actually the brief that suggested that the Ninth Circuit punt to the California Supreme Court. And so now we're in the Supreme Court, and they're picking up, based on the oral arguments, there were a lot of questions about whether Kennedy in particular, Chief Justice Roberts actually had some real questions about whether there was standing there. And I actually think even with the legal wonkishness of this issue, it's actually an interesting issue for progressive Christians. I mean, that's one of the perspectives that I took in kind of looking at the brief. What Prop 8 did was very unusual because what it did was it surgically affected one small group of Californians by taking away one right, actually, the right to the ward marriage, but didn't actually provide a real benefit to any other Californian, such that the invalidation of Prop 8, who's hurt by that? That's a real genuine question. And that becomes an issue for standing purposes because the requirement for you to appear in federal court is for you to have some type of injury. And the proponents, the people who put on the ballot initiative, the question, how are you hurt by the invalidation of Prop 8? Look over there. So they're actually, just based on the tea leaves, and it's very hard to discern anything from oral argument, but certainly I've drank my own Kool-Aid. We wrote the brief on standing, and I actually think that there may be the 4 liberal justices, and I mean less conservative justices, I should be clear about that. And actually maybe Chief Justice Roberts, I think maybe Kennedy is not so keen on dismissing the case for lack of standing. If they find that there's no standing in the Supreme Court on Prop 8, what that means is it basically vacates the Ninth Circuit opinion too, because they didn't have the right to appeal in the Ninth Circuit. But the functional effect is that the district court decision striking down Prop 8 is in effect. So no Prop 8, California's fine, it's a one-state scenario. Y'all with me? Okay, great. So now those short circuits the analysis, though, because then the Supreme Court never gets to the merits of the question, does it violate the Equal Protection Clause, right? And so if the court says, no, they have standing, we want to reach the merits of this decision, the first part of the analysis Linda's already talked about. What level of scrutiny should be applied to anti-gay laws? And there currently isn't a ruling, even though there have been some very significant pro-gay rulings in federal cases, there's no federal ruling saying that gays and lesbians, laws against them should be subject to a very high form of scrutiny. So that's potentially a really big win. And a ruling on that issue is a big win not only in marriage equality cases, but any type of anti-gay law, whether it be housing or employment or things of that sort. Now, once the Supreme Court gets past the level of scrutiny, there are different outcomes that Linda talked about, and I'm going to lay them out for you, okay? And some of you have seen this in the public, in the press about this, so I'll go through them really quickly. There's the 0-state, 1-state, 8-state, and 50-state scenario, depending on how the, right? So, but this is, I think, actually a helpful way to understand kind of what potentially the Supreme Court could do here. With regard to Prop 8, technically, if the Supreme Court says, Prop 8 was fine, there's nothing unconstitutional as a federal matter for what happened. Voters are allowed to do that. Then Prop 8 stays in effect and really no state is affected, including California, where it's already in effect. So that's the 0-state scenario. I think that's unlikely. You'd have to have 5 votes really feeling good about what Prop 8 is. And I think that's going to be a tough sell. On the other end of the spectrum, you have the 50-state scenario, where basically the Supreme Court says, yeah, not just California, and we just think kind of any law discriminating against gay people is subject to the highest form of scrutiny, and really, we're very suspicious of it, certainly with regard to marriage bans. That would have the functional effect of extending marriage equality across 50 states, and I have yet to see one Supreme Court watcher think that that's a realistic possibility here, partly because of the piecemeal litigation issue that Linda raised, right? So we're in the neighborhood of the two most realistic kind of situations, being the 1-state and the 8-state scenario. The 1-state scenario is what I would call, if you give the right of marriage, it violates the Constitution to immediately take it away. And that's a 1-state scenario because only California has done that. No other state has given the word marriage and then immediately taken it away. And that really does smell bad, right? Like it seems like the reason why the people of California did that, it wasn't for procreation, which is actually the argument that's being made by the defenders of Prop 8. It's not procreation because in California, gay couples can actually adopt children. There's nothing prohibiting. Basically, in California, you get all of the rights. And for a while, they got the word. And to immediately take away the word, if that is the rationale of the Supreme Court's decision, then you would have a 1-state scenario. It's struck down in California. The 8-state scenario is a variation of that. That would be if the Supreme Court said, no, the problem isn't taking away the word marriage. The problem is giving all the rights incident to marriage. Ability to adopt children, ability to pass property between the two partners, then spouses. Then that rationale actually affects not just California. That affects the 7 other states that have given either civil unions or domestic partnerships, where you have many of the same rights of marriage, but you deprive that word. And this is what I would call the separate but equal scenario. The court could find, no, when you give all the rights but not the word, that smells a lot like different water fountains, and we're going to strike that down, and that would affect 8 states and extend marriage equality in probably functionally 8 states. Okay? So I think 0 and I think 50 are unlikely, and I think there's a real question about whether you get a 1 or 8-state solution here. Technically our title includes DOMA, so I'm going to give a couple minutes to DOMA, because DOMA is a very interesting counterpoint. Whereas the question in Prop 8 is, what can a state do with regard to its own gay and lesbian citizens? The question in DOMA is, once a state has decided gay and lesbian citizens of their own state can marry, how should the federal government regard them? Because the only provision of DOMA that's at issue in the DOMA lawsuit is Section 3. It's not the whether one state has to recognize another state provision. It's the federal benefits provision. And so this actually, I think, could be potentially the provision that the justices don't like the most for many different reasons, because here you actually have a real incursion. It requires the government to say, yeah, I know that New York, you think that these couples are married for the purposes of state law, and I know that normally states determine who's married and who's not, but yeah, we don't like that for federal purposes, and we're going to have a federal law that kind of incurs in that area. So, and I will note, there is also a possibility in the DOMA case that actually what's called the Bipartisan Legal Advisory Group, which is defending DOMA, because the Obama administration will not defend DOMA, whether they have standing. This is a very layered, very complicated area of law. So I'm going to invoke the legal doctrine of a hot mess, and I'm not going to talk about it today. But if you want, pull me aside afterward. I can talk to you about the ins and outs of why there may or may not be standing for the BLAG. But assuming that they find that they're standing for the BLAG, and I actually think that there's probably a better argument for why a subcommittee of Congress should be allowed to defend a congressional law versus unelected people who paid a fee to put something on a ballot should represent all of the state of California in litigation. So assuming they get past the issue of standing, there are basically, as I see it, two issues in DOMA. There's the 10th Amendment route, and then there's the 5th Amendment route. So the 10th Amendment route, which I actually wasn't that paying attention to this route, but it came up a lot in oral arguments. Justice Kennedy asked a number of questions about, before we even get to whether Section 3 of DOMA violates the Equal Protection Clause, did Congress have a right to pass DOMA in the first place? That is, what is the basis for federal authority to pass a law that essentially incurs on, that affects 1,100 federal statutes at the same time, and, to quote Justice Kennedy, that really gets involved in the day-to-day lives of state citizens? Now, this is a really tricky area because, 10th Amendment historically hasn't been the best basis to kind of win cases in the Supreme Court. I just note it for you because if you get votes that stop at the 10th Amendment analysis and say, you know what, they didn't have a right to pass DOMA in the first place, you might not get to the equal protection analysis later. The equal protection analysis is the one that's much more interesting for folks. It's the one that would require finding that gays and lesbians are a suspect class, how should we scrutinize laws against them, and then essentially if DOMA is struck down on an equal protection basis, about 9 states are affected. It's the 9 states that have already extended marriage equality, okay? And so that would mean that gay couples in those states that have married will get federal benefits. It wouldn't affect the whole United States, right? Because it's just a matter of federal benefits. Does that make sense? Cool, okay. So actually, I think we're doing pretty great. We have about 10 minutes, right, for Q&A. Can I make 2 kind of quasi-theological points about the Prop 8? Because we're talking about the arc of justice. I wanted to point out a couple things, which for me, kind of in working on these cases, it's been very interesting for me to bring to bear kind of my perspective as a progressive Christian. One is the issue of, that's actually raised by Linda, is how do we scrutinize anti-gay discrimination generally, not just with regard to marriage? Okay, and for me, the analog is to when Jesus refers to the least of these. How are we suspicious of the most marginalized laws that target the most marginalized people in our society? And there's a real question right now in the Supreme Court arguments about, are gays and lesbians that group? Because Chief Justice Roberts, if you read the transcript, he's not that impressed with this argument. He says, what are you talking about? You guys have made so much progress. You've had a sea change in the last 10 years. And of course, the retort to that is, it's a sea change given how far back gays and lesbians have been set. No other group is the subject of regular referenda targeting their rights. So the question of, are gays and lesbians politically powerful? Are they a marginalized group? I think that's a very interesting issue for progressive Christians to really mull over, because it's part of kind of our commitment to kind of work out justice issues. And I think there's real synergy there in terms of our standing up for the fact that you know what, gays and lesbians are a marginalized and targeted group, and there is something good about federal courts being very suspicious of laws that do that. The second theological point I will raise is kind of, and actually Susan is the person that's kind of helped me think about this issue a little bit, is it a hearts and minds win, kind of an incremental win as you kind of convey story to story, person to person? Or is it an Easter win, just one big win, one big victory that really makes a difference across the board? And all of the reading that I've done about people trying to predict, this is a really hard case to predict. But for me, the end result is maybe, it's very significant, but equally significant is the process by which we engage in justice work. You know, the actual full statement from MLK on the arc of justice that we like to refer to is, I haven't lost faith because the arc of the moral universe is long, but it bends towards justice. And we tend to focus on that last bit because it's the most results-oriented part. The end is justice. We win. It's great. But I do think the first part is equally important, where Reverend King is admonishing us to not lose faith and to continue our justice work. So no matter what happens in terms of how Prop 8 and DOMA are going to be ruled on by the Supreme Court, even if you get the big 50-state win, gays and lesbians are not going to be the last group that people target for discrimination. And so for us as a faith community, it's a real question about how are we going to engage the court process and what are we going to support in terms of all of the groups that we think deserve, you know, a closer look when they're being targeted against. So that actually has been a really informative part when I've been approaching our involvement in these cases. It dovetails with kind of my theology, and I think it dovetails with All Saints'. So something for us to think about.
While our volunteers are bringing the microphone, I'm going to make two very quick points about where the Episcopal Church stands on these issues, not just All Saints, but the whole Episcopal Church. You should know that our last General Convention, when we met, we passed overwhelmingly a resolution that called for the repeal of DOMA, the Defense of Marriage Act. It was so overwhelmingly passed that those of us who presented the resolution didn't even get to speak for it because no one stood to speak against it. Seriously. So the Episcopal Church is officially on board as opposing the Defense of Marriage Act, and I believe we are the only mainline denomination that can say that. Also, when we talked about the amici, the Friends of the Court brief, one influential brief, two actually, one on Prop 8 and one on DOMA, were filed, signed by 29 Episcopal bishops. All the bishops save one, who I shouldn't probably tell you, it's Albany. Who live in jurisdictions which either had or have civil marriage signed on to this. 29 bishops. And again, talk about sea change. I think we couldn't have even imagined that not that long ago. So we stand very firmly in the Episcopal Church in favor of this work. And now I'd love to turn it over to folks who have questions for our speakers. Yeah, here and then up, Ray.
If there is a solution that's less than 50, leaves open the question about what are the obligations of the anti-gay marriage states to recognize marriages that take place in the states that do have it. So what is the state of the law on full faith and credit in a situation like that, which I understand is not an issue in the Supreme Court. So where is the law there?
I think generally there is a recognition of full faith and credit between states, and so it's usually the case that a marriage is recognized in one state and taken. I mean, one exception, I guess, would be the age limit, maybe. But
outside of this.
Yeah. But there is generally a feeling that, you know, it's a good thing for states to kind of acknowledge what happens and what's decided in other states. But as you pointed out, that's actually not at issue. And that's part of Linda's point about the incremental litigation. There was a choice to target Section 3 and not Section 2, which is the full faith and credit issue, because I think there was much amongst the gay rights advocates, and I actually really view DOMA as kind of the child of actually the gay rights community, because that's part of the incremental process that I think the classic gay rights activists have pursued. And so they wanted to go for the targeted strike down of DOMA Section 3 first. And I think part of the thinking was that if they could get reasoning that either applied heightened scrutiny to gays and lesbians, that could maybe later get applied to a Section 2 challenge. Basically, see what kind of win they could extract at the Section 3 level. So, yeah.
There's also a long-term legislative solution potential toward Section 2, because the more states there are that have either domestic partnership laws or marriages, the fewer states there are to push back against recognizing those sets of rights. And so in some senses, Section 2 is more of a hearts and minds argument, although we could go on and on about the full faith and credit aspects of that and whether it's constitutional itself. You can sort of see the path toward a repeal of Section 2 in a way that may make sense in the relatively near future.
Ray and then Giang.
I have two questions. The first one is, if I remember correctly, you explained how Justice Kennedy was asking questions regarding Amendment 10 and whether Congress had the right to pass DOMA in the first place. And if they were to determine that, then would their decision be to strike down all of DOMA, even though only Section 3 has been put forth to the court? And then the second question is regarding standing. If the Supreme Court determines that the plaintiffs did not have standing either in Prop 8 or in DOMA, can they still choose to make a wider decision regarding DOMA and Prop 8 and providing heightened scrutiny and doing more than they have to?
The second question is the easier one to answer. The answer is no. If the Supreme Court finds that either the proponents in Prop 8 or BLAG in DOMA did not have standing, it's actually a jurisdictional doctrine. It basically says that if the person that's appearing before the court shouldn't be appearing before the court actually doesn't have power under Article 3 to even hear the case. And so it wouldn't go any further than that. That's why I described it as a threshold issue. And I think it's more of a threshold issue in Prop 8. Actually, your first question gets to something I didn't get a chance to talk about, which is kind of the relationship between the two cases. If there are 5 votes for the 10th Amendment issue, that the federal government didn't have power in the first place to pass it, I don't think they would reach Section 2 simply because. First of all, courts only hear the direct case that's immediately before them. Their reasoning might be used in a later case to challenge Section 2, but as a general matter, especially this Supreme Court, it tries to be careful about only addressing the issue that's before it. But the 10th Amendment issue that you raised actually creates this weird tension with Prop 8 that I don't know if folks have kind of picked up. If the Supreme Court says, you know what, yeah, we really don't like it when the federal government intervenes with state marriages. Marriage is traditionally a province for states. That creates a problem for Prop 8 because one argument for Prop 8 is, well, the state did say something. It was trying to regulate its own marriages there. So if you have a federalism rationale in DOMA, does that become an issue would the court feel compelled to essentially uphold Prop 8 as an exercise of states' rights? I don't think so. I've seen some conservative commentators say that is a requirement. I personally don't think that's the case. I think potentially you could have 5 votes to strike down DOMA, 4 votes for equal protection, 1 vote for the federal authority issue. And then when you turn to Prop 8, I think you could still have a consistent standing dismissal or a one-state solution. Because what could happen is this. Justice Kennedy could say, I have a real problem in terms of the federal authority to pass DOMA, especially Congress to really invade states. But really the issue in Prop 8 is not a legislature kind of coming, it's not like Congress coming in a stamp on the people of California. It's really a question about what's the role of federal courts. And I think there's a way for Justice Kennedy to say, whatever my federal concerns are with regard to what Congress did in DOMA, I still believe in the power of federal courts to enforce the Constitution and protect persecuted minorities. And what happened in California was very unusual. It was such a targeted thing that is someplace where federal courts should step in. And in that case, you would have a DOMA strike down by 5, and then potentially 5 votes to strike down Prop 8. Does that make sense?
Well, with profound apologies to those who still have the microphones, it is 11 o'clock and we have got to go to church. So please join me in thanking our fabulous fellow parishioners for their legal expertise. Thank you all now, and stay tuned for further developments.